rotate bugger. I'll wait for a few people to come in. Can you just say if you can hear me, please? And I'm trying to get my screen to rotate, but it won't at the moment. I don't know why. Maybe if we take that off. I'm going to be going through. Can you let me know if you can hear me? Yeah, that's good. I'll just wait for a few more people to get in. I've got access to the documents. I don't know why I can't rotate my screen, and it's a bit of a pain. Sorry, this is the first time I'm actually live streaming from my phone, but I'm going to show my share my phone screen. I've got some motions here. I would like to rotate my screen because it's going to look better, I think. But if we're stuck with this, I'll stream this way. What, can you let me know what it looks like on a screen? Is it okay like this? Because if it's okay like this to go through the motions, I'll stay like this. Right. Let's just pull him down here somewhere. Reduce him down a bit. Right, sorry, just bear with me. I don't know what's happened there. It stopped playing. Why has that stopped playing? I don't know. Oh, we'll do without the frog. We'll do without the frog in the corner. Let's get rid of him. Right. Okay. Right. I can't get to, hang on, I'm going to take the, just take the comments off for a second while I get to where I need to get to, my files. Right. Down here you will see that we have lots of PDFs, and they're all from Deboraugh Rodgers court hearing. So let's start, shall we? Let's start with the original charge. Right. Does that look okay? Or do you want me... Let's see if it will rotate. Oh, it has rotated. That's good. Right. That's where I wanted to be. Right. I'm 3 minutes into my live stream, so I suppose I better get going. Let's get those comments back up. Right. So, Cherokee Nation v. Deboraugh Rodgers, CM-21-772. And she was charged with 3 counts. This is the original charging document, 7 May 2021. Driving a motor vehicle while under the influence of alcohol, incapable of safely driving. Count 2, resisting an officer. Count 3, transported loaded firearm in motor vehicle. And let's look at the specifics. So it's just the vehicle she was driving, the place where it occurred, which appears to be in the F.UK.T, I can't say that, parking lot, Tequila, Oklahoma. So that would suggest that she was on Cherokee tribal land. So she resisted the officer. Well, we've seen that on the video. I don't know if you've seen, but I posted the video as best I could of the event all in one. I had to grab together all of Chili's videos and sort of compress the screen to try and get it looking good. So we saw a resistant officer. I think that's fairly clear. And, well, we didn't see this, but that she did commit the crime of transporting a loaded firearm in motor vehicle. And it's given the details of the firearm, a 9mm Taurus. Again, occurred in the Cherokee Nation. And we've got that she is a victim. She qualifies as an Indian as defined in 25 U.S.C. section 1301, being a member of the Cherokee Nation, a federally recognized tribe. So there we go. So that's the original. So let's go back to my files. Right. The second one we're going to look at. Where did I find the Rodgers Motions? Well, I found them on the Cherokee Court site. That's where I found them. And it's quite easy to find them. Right. Now that the information has been changed. If you notice, this was filed the 26th, which is today. I was just checking. It's today in your country and my country. And again, we have the counts. Are they exactly the same? I think they're the same. So let's just check. Because Chile is talking about a felony. I don't know if anyone can look up those statute numbers, because it's definitely saying count 3 is a misdemeanor. Right, well done. Because I'm looking at these as I haven't actually looked at these myself in detail. I thought I'd go live, share them with you, because I know a lot of people want to see what the actual details of the case are rather than what Chile says. Yeah, motor vehicle while under the influence of drugs. So that's this will be interesting. Does this work? Oh, it does. There we go. Under the influence of drugs. Driving a motor vehicle while under the influence of drugs. Now, can I get rid of it? Yes, I can. That's good. And let's go back to the original information, which was while driving under the influence of alcohol. So they have changed that charge, and well spotted. It's hard for me to read I can see the comments, but it's hard for me because it's in orange to read who said the comment. That's almost. I'm sorry, I cannot read the names of the comments. I am on my phone, as I said. First time I've gone live on my phone. But that's the one that's changed. Influence of alcohol. So there is a recent change in the charge. Now, I don't know if that's made it a felony or not. Let's go back to the second one. And look, does it say it's a felony? Doesn't say it's a felony. I don't know if someone can look that up to see if that is a felony and type it in the comments. The sections are there. Because it definitely says a misdemeanor under the loaded firearm. There, misdemeanor. But doesn't say anything about the other two charges. But Chile is saying she's been charged with a felony. So it'd be good if we could verify that. Anyhow, so those are the information. Now, when I was looking through this, and we do have the defendant's motion for jurisdiction, and I will go through that. That's the probable cause. Is that the probable cause? Or have I opened up? No, that's a different one. Sorry. Apologies for that. too many documents here. Right, now there is one I'm looking for, which is, and I can't see it. Why can't I see it? Files. Let's go back. That's better. They should all be here. And there is one, there it is, that I thought was interesting. Because she was initially represented on this case by an attorney. And he withdrew on the basis that she had retained other counsel. So she was originally, so a second offence for driving under influence of drugs is a felony. And I don't know about the first. It'll be interesting if there is a felony or not. But there we go. Deboraugh Rodgers has retained other counsel. But as she is saying at the moment, she is pro se. Right. So I think those were the major things within the docket. And she is on the docket today. But let's go to, and obviously the order allowing the withdrawal of was granted. So he was allowed to withdraw as attorney. And that happened 19th day of April 2022. Now you've got to remember the offence was back in spring 2021. So he'd been in there for some time. All right, now this is the motion. And I am looking at this with you. Can you read it? Is that big enough? I can make it bigger if you can't read it. I don't know how much we get through this. It's obviously going to be quite boring, but I think we're all interested in... Let's actually see who signed it first. I'm going right down the bottom. And signed by herself, pro se. So her attorney withdrew in April 22. Actually, I can see the orange now. It must be the light here. So I can see Alex, Don, Iowa Hawk. Aim for W. Goat's Love. It's the problem is against the white, I think, that I can't see it. So yeah, she has a hearing today. So there is a hearing today. So there'll be an update on that later. Right. So she's saying that she is duly enrolled member in the United Katoa Band of Cherokee Indians and a citizen of the Cherokee Nation. So appears that she's admitting that she is a member of the Cherokee Nation. Does say 3 misdemeanor counts. Now, this is interesting as to whether the change in that account has made it a felony, and hopefully that will become apparent. So she's entered a not guilty plea. The arrest occurred within the Cherokee Reservation, so she's admitting that in her motion. So she's admitting that she's Cherokee and that she was on the Cherokee Reservation. The UKB, okay, United Katoa Band. So she's stating that the UKB, which she says she's a member of, possesses the civil and criminal jurisdiction over the Cherokee Reservation. But then she's saying the Katoa is the traditional name for the Cherokee people. So, so this is all the history of the Cherokee in Oklahoma. I don't think there's anything. I'm just scan reading it through with you. I hope I'm going at a decent speed so that you can read it as I go and it's not too slow and not too fast. Now, I have got one of these foldable phones, so the screen is not exactly the same shape as the 16:9 resolution, so it may be a bit squashed for you on your screens. That's the reason. Right, so she's gone back to 1839, talking about faction of the Eastern Cherokee known as Ridge Party signed the treaty, ceding the Eastern Cherokee lands and agreeing to join the Western Cherokee lands in Indian Territory. Right, talking about two factions. So we go right back in history. So after the Civil War in 1866, the United States treated with the Katoa and the Cherokee Nation factions as one government. Oh, God, she's going through a lot of history here, isn't she? I'm gonna go quite quickly over this because then in 1906, the Oklahoma Enabling Act assisted in the admission of the state of Oklahoma into the Union in 1907. This was only made possible by denying the Indians the right to have their own state. Right, then during the Great Depression, you possibly know all of this history, but it's quite interesting for me. There was a Indian Reorganization Act that was intended to restore to Indians the management of their assets and government. So this was to allow Indian reservations or Native Americans to control their own affairs. So the Katoa through the mid 1900s were getting together, forming a constitution. And the U.K.B. constitution identifies a Cherokee reservation and its historical districts as the boundaries for the election of officers and district representatives to serve on its council, the governing body of the U.K.B. It also requires council meetings to occur within Cherokee Reservation. Right, the CNO failed to take advantage of opportunities to form a government as provided by federal law. And this is what she was told. I mean, it's bonkers, isn't it? So they were recognised by the federal government, but she's looking for the word authorised, requisite authorisation. Here we have a situation involving the legitimacy of the tribal court created by the tribe that has not received the requisite authorisation from the federal government. Now, in my own mind, I'm thinking, well, if their court was not valid, then how the hell has it been allowed to operate by the attorneys operating for the defendants there for years and years and years? I mean, my mind says that surely an attorney would have found this defence for their client many years ago. But oh no, here we have a pro se litigant who has found the errors in the construction of the Cherokee Nation of Oklahoma. So the CNO, Cherokee Nation of Oklahoma, and the U.K.B. coexisted. She's gone back again. She's gone back in history now. Ah. CNO neglected to take advantage of the OIWA and did not pursue federal recognition or approval by using the process provided by the federal government. Well, this is all gobbledygook, isn't it? The Cherokee Nation of Oklahoma is not entitled to have the tribal courts and thus has no authority in this case. But they got a nice courthouse there. They got judges presided in that courthouse. They're deciding on criminal matters, many criminal matters. When I've been trying to find this case, I've seen many criminal matters appearing in that court. But apparently, there's no jurisdiction. They don't have jurisdiction over anything. The Department of Interior promulgated, these words. Wonder where she's got that from. She surely hasn't come up with that for herself. So in 1975, they wrote a constitution, apparently hoping that said action would be accepted by the federal government and give Cherokee Nation of Oklahoma the appearance of having satisfied continuity of government required by 25 CFR 83.4 brackets B. But that hope was misplaced. A new amendment to the 1975 Constitution, which purported to supersede both the 1839 and the 1975 Constitutions, was still being argued with the BIA well into the 21st century. Interesting. The federal scheme for approval by the Department of the Interior. This brief, I mean, she's really got some legal terms here. Done a lot of history. And she's talking about the Cherokee Nation of Oklahoma doing nothing. Well, Native American laws apply on their land. Yes, this occurred on their land. Sorry, I just read a chat. So she's saying that the Constitution that the Cherokee Nation of Oklahoma adopted in 1975 was not approved. And she's going on about, obviously, the legitimacy of the referendum. This was the first time the Cherokee Nation set themselves apart and called themselves the Cherokee Nation of Oklahoma. And there are other Cherokee nations, but she is a member of this Cherokee Nation in this tribal land. All right. Okay, the 1999 Constitution. So again, she's saying they didn't get approval. And she's quoting approval with 25 CFR 83.4 and 83.11. And it was allegedly approved by referendum in 2003. The referendum was tainted from the beginning. But again, there is a problem regarding the election. The Constitution required that there be 15% of the eligible voters to cast a majority vote in order to approve the Constitution. OIWA Section 5203 requires such voters to have participated by 30%, not 15%. So she's going back in time and saying that a 1999 vote on their Constitution was not valid. Again, I just, surely someone will have attacked this way before now. So we've got invalid constitutions after invalid constitutions. Retired road dog, hi. Sorry, we're just going through the motion here. The early part of this looked at the charges, and we're trying to work out if there's a felony. It has been amended today. So she's facing the court today, and there is an amended charging document. So the District Court and the Supreme Court of the Cherokee Nation of Oklahoma were established on November 13, 1990. So we're now 32 years that it's been in existence, or almost 32 years, at a time where there was no authorization in effect for those courts. And then she's going back to 1839 again. I mean, so she's putting a motion before the Cherokee Nation of Oklahoma, before that court. She's putting a motion to that court, and the court doesn't exist. So what's the validity of the motion that she's putting forward? Because if the court doesn't exist, or isn't valid, then any ruling they make on this motion is surely invalid. So we've got defunct constitutions. Right, 4. CNO courts still operate under a cloud of illegitimacy, lack of judicial independence, and unrepealed congressional ban on Cherokee court system taint tribal judicial process. So she's saying they are still operating under first the so-called Cherokee Supreme Court. Well, that will make her go down well with the judge, I would imagine. Functions without semblance of judicial independence are in the tribal executive branch. Throughout their terms in office, Cherokee Supreme Court justices remain subject to the unabashed influence, if not overt control, of the tribal executive branch, or more specifically, the principal chief of the CNO. In a word, the CNO court system is rigged. Meaningful judicial review of the abusive misconduct of tribal executive officials is therefore practically impossible. Well, let's go back to what this case is about. She is alleged to be under the influence of drugs now when this offence took place. We've seen from the video that she did not comply. We've seen from the video that she resisted. And we don't know about the firearm. We don't know that she was under the influence, and that's obviously up to the tribe to prove that she was under the influence. But if she's not under the jurisdiction of the Cherokee Nation of Oklahoma, she's under someone's jurisdiction, and that's a crime under, I would imagine, any jurisdiction that she would be under. So she's going to have to suffer the process of going through the court procedure to find out if she's guilty or innocent. So I just don't understand it. Although we have discovered that there is a case which was initially charged, and it's illegal carrying a firearm, I think, or firearms in the wrong place or something like that. It was about a year earlier. It started in the Oklahoma county system, and it was transferred to the tribal court, and it appears that the tribe took no action in that event. So she has
it appears that she managed to get off a crime by a switch from the Oklahoma district court system to the Indian court system. The Shadow of the Curtis Act of 1898. So we've gone back again. So I don't think we need to read through that. So she's found a case, Hodel v. Muskogee Creek Nation. Right, and that appears that they did have a right. Have to look at that. Oh, we're at the bottom. I think we're at the bottom. We're at the bottom. We are at the bottom. So she's done lots of arguments. She's given one case. Just trying to work out the CNO courts are. That's interesting because I think a well-written motion would probably have sort of morning Ed Ramirez. I'm sorry, I sometimes can see who's in chat and sometimes can't because of the font that the chat is using. I am live streaming from my phone. First time I've done this, so this is a bit of an experiment as well as going through this documentation. And you're getting some Telegram messages there, which don't really matter. Yeah, I would expect a summary or something here, but she goes straight from quoting a case to. Hang on. So she's talking about. Even in the same. She's in the same paragraph. This is bizarre. So she's talking about this Hodel case, and within the same paragraph, she then goes into argument. So I think, where do we start? Is the since? So the since, I think, the since should really. I think that's where she should have stopped talking about the case and gone into another section. Given her concluding argument, because this would appear to be her concluding argument. Since the 1999 Cherokee Constitution was not adopted pursuant to the OIWA, the General Repeal Clause of the OIWA does not apply to restore CNO's legal authority to create and maintain a tribal court system. Thus, until reorganization under the OIWA occurs or Congress repeals the Cherokee tribal court ban, CNO tribal courts are operating in overt violation of federal law, as embodied in the still applicable 1898 Curtis Act and the 1901 Cherokee Agreement Statute. The Cherokee Supreme Court, like every other CNO court, has no legal authority until Congress expressly repeals the Cherokee court ban or the CNO reorganizes under the OIWA. The CNO courts are illegal and have no authority or jurisdiction to act in defendant's case. The motion to dismiss should be granted. Well, we know it's SCOTUS rule this year that states have jurisdiction on tribal land. Well, that's it. I mean, she's under the jurisdiction of someone. So wherever she is, this will probably proceed to trial. Now, as I said earlier, surely if this was a defence, this defence would have been used many times by many defendants in this court. She's actually arguing that the court she's arguing before is illegal and have no authority or jurisdiction. So if she's arguing that this court has no authority, what I can't work out is what is the point of this motion, because if the court has no authority or jurisdiction, she should surely be arguing this matter in federal court. That's where her argument is. Her argument is with federal court, and for federal court to sling an injunction on the CNO to say you can no longer operate because you don't have authorization. I mean, she's arguing, to my mind, she's arguing in the wrong place, because she's arguing against herself. She's saying you can make a decision on my case, but it's unlawful. You are unlawful. So I don't understand how she can argue that they can make a decision in her case. It's in the wrong place. It's full of history. It's easy to find. I won't. No, because there'd be a link in Merb's. I would expect it's going to be in Merb's document store. Where was I? Yeah, it's going to be in Merb's document store. It is easy to obtain. We struggled to find it. It would appear that the case number, either because it has been updated or something, it couldn't be found on the Cherokee Nation of Oklahoma's court's website. But their website is dead easy to find documents. We've got the case number now. You've also got a name. She's on the docket for today. So if you want to get the PDF yourself, it's very easy to get. Right, what have we got here down the bottom? So she's so sorry, I'm doxing her address there. I didn't mean to do that. I suppose if you file pro se and give your address, it's going to be. So she's given. So she's given some background. I suspect they. Well, this is just historical. She didn't even. Did she say exhibits or anything? Sorry, I'm going back up the top, because these documents just appear. She doesn't say exhibits or anything. They're just there on the motion. I mean, does she expect the judge to read these? I don't. Oh yeah, sorry, they got the exhibits there. Okay, so maybe they have been accepted as exhibits by the court. I have to say the website for the court is very nice to navigate and get to the documents. A lot nicer than many district courts. So I know you can't read this, but as I say, I thought I got to the bottom, but this is all constitutions of the Cherokee Nation of Oklahoma, various versions thereof, I think. Sorry, I'm flicking through these. Oh, that's it. So she's attached various. So, what do you reckon? Motion's going to be granted or thrown out? Well, the motion's going to be thrown out. Then what's she going to do? She going to appeal to their Supreme Court? No. Motion's going to be thrown out. You're telling us that we can't make decisions, so any decision that they make, even at the Supreme Court level of the tribe, is worthless because we're unlawful. So it's going to be thrown out. So it's going to be thrown out by the judge today. It's going to be thrown out by the Supreme Court if she takes it to the Supreme Court of the tribe. And then what's she got left with? What's she got left with? She gonna take this case federally to prove that the Cherokee Nation of Oklahoma's courts do not have jurisdiction over the lands of the Cherokee Nation of Oklahoma. Oh, pathetic. Sorry, I'm all right. So we looked at the motion to withdraw. For those that have just joined, she was represented by an attorney who withdrew in April 2022. Let's have a look at these. So this is the case just going through the court. This was a motion by her attorney back in July 2021. So this is a discovery motion. Well, we know she got the video recording. I don't know if there's any blood evidence or anything. Standard discovery motion. I mean, it's in a tribal court, but it just looks like a standard discovery motion. So it talks about laboratory tests. Be interesting if there were laboratory tests. But as I say, it's just a standard discovery motion. It's a cover-all, isn't it? And he's given his authorities. You see, right. Oh, gone back too far there. Right. And there was another motion filed by the attorney. Oh, two firearms. She obviously was ambidextrous or something. Oh, no, this is pro se. She's gone pro se. Hang on. Oh, yeah, this is recent motion. June 2022. So they seized her firearms April the 7th, 2021. Hang on. So there's one firearm, the 9mm Taurus. So where's the other firearm? Do you see two firearms in there? I don't see two firearms in there. So I'm seeing this. I'm seeing people say hello. Johnny Groman. I wonder if they did a. Wonder if they did a search of a property to get the second firearm. The defendant is a single woman and considered an elder among her community that resides alone and the longer both the firearms and accessories is held as evidence, the more fearful the defendant becomes. All right. Well, as I say, she's got court today. You can go and obtain these, go back to the charging document. This is the one that's up for today. And I don't know if the person who identified the change in the two charging documents, but I've got to keep on saying state, but it's not. The tribal court has changed the charge from driving a motor vehicle while under the influence of alcohol to driving a motor vehicle while under the influence of drugs. And it is possible, if she's got previous conviction, that this creates the felony charge. But unsure about that. We'll wait and see what comes out today. Thank you for joining. I think we I've been live streaming now for 46 minutes. Unusual for me, this one, but I thought as the documents just become available, it'd be useful to see what the facts are from the court as opposed to what Chile tells us. And you'll see earlier, well, I did it yesterday, I put together as best I could the body cam. She didn't have the first about 8 minutes of the body cam. She'd hidden the video on her. She privatized the video on her channel. So I had to put together what happened in that first part from Chile's video, which was a lot of copy and pasting because he kept on moving his hand. He was videoing his camera to the laptop, but I did put together as much as I could the whole events of what occurred that day, and subject to the evidence, which we don't know, as to her being under the influence, and the fact that they're now saying drugs. Did they discover something? They must have discovered something. It looks like she resisted to me, and it looks like the firearm that seems a matter of fact. If the firearm wasn't being carried safely and that's against the tribal laws, then so be it. She's going to be found guilty. I mean, I suspect that this motion is just going to go the way of most of Chile's notions and be dismissed. Thank you for watching. I should say this. I've got to be Chile, haven't I? I've got to say, "What's up, Playboy?" And I've got to say something like, "Please take your finger and push the like button." It doesn't take very long. Don't do it. Do it now. Do it now. We got 50. Oh, we've only got 20. We got 20 in here, and I've only got, I don't know how many likes because I haven't looked, but you can. Anyway, press that like button. Subscribe if you're not, and I'll catch you all later. Thanks for joining me. Cheers. Bye bye.